Brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, listeners, learners, teachers, trainers, professors, professionals, officers, officials, the most honorable President Prime Minister Modi ji, respected doctors and directors, adorable ministers and managers, honorable advocates, advertisers, administrators and advisors, the most honorable President Prime Modi ji, I do Rakesh from USA, heartily, cordially welcome. It is really nice time, nice place, nice section today that we are appreciating our holy cultural identities in the form of unity, diversity, which is the greatest feature of our nation all over the world. We are known by diversities, adversities, but the greatest identity of our nation, that is unity in diversity. Our own spiritual starters, beginners, initiators, generators, operators addressed us unity, oneness, equality, universal love. Let us define how we have constitutional unity, equality, oneness. Information technology law. What is cyber law? Let us discuss its importance in modern world. Let us explain its definition and importance of cyber law. Definition of cyber law is most of the countries of the world have made their own cyber laws for the prevention and control of cyber crimes. The borderless medium of internet has increased. The incidence of cyber crimes, which requires effective cyber law to limit and control them. In short, cyber law is a law which includes within its scope various types of political, economic and legal matters related to the internet and other communication technologies, which also includes intellectual property, right to privacy, freedom of expression, etc. Thus, cyber law can be called that branch of law which which deals with newly emerged legal questions operating on cyberspace as a result of the development of the internet and other communication mediums. Cyber law is important because it regulates almost all transactions and activities related to the internet, World Wide Web and cyberspace. The development of internet has given rise to various types of crimes and many questions arising out of intellectual property rights, e-commerce, encryption, electronic contracts, online banking, etc. Computer systems can be breached by cyber criminals by attacking them, but due to the specific nature of cyber crimes, it is difficult to identify and catch such criminals. In today's modern computer age, it has become very easy to misuse the internet and use it for distant purposes or for selfish purposes. The internet is seen as an effective medium of communication. It is seen as a source of knowledge, a means of disseminating information, and a channel of entertainment. Therefore, it can be said that its work is multidimensional in nature. Being multidimensional, the crimes that are facilitated by the use of the internet are also multidimensional. This has made it necessary for all governments in the world to implement regulatory measures within their legal framework to curb cybercrimes and related activities. Cybercrime is a wide range which can take the form of pornography, money laundering, banking, and credit card fraud. Cyber defamation, threats, and email threats. In this way, cyber law can be defined as a method of regulating cyberspace that arises from connecting two or more computers together through a network in a non-physical area. Online systems create a cyberspace within which computer users can communicate with each other. Considered from this perspective, the term cyber law refers to the law related to computers and computer networks, and which includes all activities such as storing information, exchanging them, or reproducing this information through the use of computers. According to Wikipedia, the current use of the term cyberspace refers to the global network of interconnected information and interconnected information technology infrastructure, telecommunication networks, and computer-based systems in which online communication occur in this cyberspace using the internet and global networks. Individuals can interact with each other, exchange ideas, share information, conduct business transactions, direct their actions, play games, participate in political or social discussions, and many similar activities. Anything related to the internet and computer network comes under the field of cyberspace. It is needless to say again that cyberspace does not recognize any territorial boundaries. Therefore, a person skilled in computer operations can very easily defraud a person having a bank account in the United States. Again, the extremely fast mobility and efficiency in cyberspace provides further convenience to cyber criminals to remain unidentified and undetected for crimes committed through computer networks. Violation of intellectual property and privacy rights are other vulnerable areas commonly operated by cybercriminals. There is a need for special and separate cyber law to deal with. There is a need for a special and separate cyber law to deal with and arrest these criminals. Necessity and importance of cyber law. Although the present era is considered to be the era of information technology, and more advanced the country is in information technology today, the more developed and progressive it is. Today, due to the over due to the ever new research and development of information technology, the whole world has become a global village. But with the development and progress of this technology, cybercrimes are also increasing at a rapid pace. As a result of this, today our bank accounts, our personal data of TM, mobile phones and laptops, confidentially files related to defense, information related to our research and discoveries, online transactions, confidential details of our lives, etc. Nothing seems to be safe. To protect them, the biggest need in the whole world today is for a system and law that can keep them safe and in case of their violation, identify the cyber criminal and bring him to justice and provide justice to the person suffering from it. Thus today, as much as there is a need and importance for the methods of developed by information technology, there is there is an equal need for a method that can make its use reliable and safe in all respects. Thus, in today's time, there is a need for cyber law and it also has great importance. One is more than 50% of the websites of America, Britain, Canada, and other European countries are facing the problem of security breach and cyber terrorism. India is also not untouched by this. Only a rigorous and comprehensive cyber law can provide relief from this. In the absence of comprehensive and strict cyber laws, no website can remain safe, nor can its use be safe for us. Although many countries have made their own cyber laws due to lack of uniformity in them, international cyber hackers are neither properly detected nor caught. With the revolution of information technology, the internet has become an important means of obtaining information and transmitting information at very high speed, which is being misused openly by various extremist groups and terrorists. This is why terrorism is spreading at such a rapid pace and terrorists are able to easily hit their targets by sitting at a distance. A global An effective cyber approach is necessary to deal with this type of cyber terrorism. Next is, what do you understand by the term cyberspace? Let us explain evolution and development of cyberspace. Let us define term cyberspace. Let us state origin and the importance of cyberspace. What is the mean by cyberspace? Let us discuss need and importance of cyber law. In the present era, mediums like radio, television, and World Web have not only certified the society extensively, but it has also greatly increased the scope of research related to anthropology. As a result of this, in today's era, space has created a virtual world that has given rise to innovative social and cultural practices. In this, a global society has been created by breaking the boundaries of nation state. The cyberspace and the internet have revolutionized the means of viewing, representing, and communicating. The term cyberspace was first used by William Gibson in his 1984 novel Neuromancer. In fact, the term cyberspace is used for the environment created by the interconnectedness of computer networks or their mutual interaction. This term became more popular in the 1990s when the use of internet was increasing rapidly and the need for a short term for the situation and social and mental phenomena arising from it was felt. There has been an unprecedented increase in the number of internet users in the last 3 decades, since crores of people are joining it every year. There is a possibility of expanding the contemporary economic and social space of humans through cyberspace such as email, e-commerce, e-learning and e-governance, etc. is being expressed. This expansion is much wider than the current communication system and transportation. Hence, it has turned the idea of global village into a real concept today. Cyberspace and internet are not synonyms of each other. Both are different things. The internet is a system of interconnected computer networks that use the internet protocol suite TCP or IP to link global communication devices. In fact, it is a network of networks that includes private, public, commercial, and government networks of global networks which are connected by a wide range of electronic, wireless, and optical networking technologies. While cyberspace internet is the word of virtual computers, which are computers work on the interactive environment of the network. Thus, cyberspace is the word of information through the internet. Thus, cyberspace means exchange of information, communication through the internet through some invisible technology. It has no physical feeling because it is neither visible nor can it be experienced by touching. Still, its influence is everywhere in the world. In short, cyberspace can be called an imaginary contract in which all the information resources of the world are operated in a combined form, but which are neither visible nor can be experienced by the senses. Its origin and development of cyberspace. In the modern perspective, The term cyberspace was first used by an American Canadian novelist named William Gibson in his novel Neuromancer, published in the year 1984. In the plot of the novel Neuromancer, humans roam in cyberspace while storing their consciousness in the matrix of a computer. But even before William Gibson, the word cybernetics, similar to cyberspace, used by the famous mathematician Norbert Wiener 1949. In fact, cybernetics is a mathematical concept in which electronic control systems are compared with a human nervous system. Later, when the use of internet started increasing in the 1990s, this word started being used for the internet and its activities. Today, when the internet and computer systems have developed a lot, cyberspace has become such a virtual world where there are many activities which we cannot see or touch but can definitely feel around us. Due to its immense capabilities and immense possibilities, this virtual world has greatly influenced our real life, and it seems that life can be no longer run smoothly without it. Today, it is expanding rapidly in every field, be it business, education, governance system, countries, defense, and health. Everything has become under the purview of cyberspace. The use of mediums like electronic communication and soft copy is increasing day by day. Due to its multi-dimensional use, many new possibilities like communication, networking, activity, and entertainment have become easily possible and accessible to all through the internet. Through this, the pace of development has also increased and monitoring of development projects has also become easier, but along with many advantages. Increasing cybercrimes have also given rise to many problems which need to be resolved by cyber experts. Need and importance of cyber law. Cyberspace emerged in the 1990s, 1990s, and paradigm of its development that it has proved today is unimaginable in itself. Even today, it is developing rapidly in every field: business, education, health, banking, knowledge science, transportation, communication, space, employment, country defense, governance systems, etc. Nothing is untouched by its influence. Anyone, anywhere is free to do anything in cyberspace, while its prevalence in human life and freedom of its use has made our lives extremely convenient and easy. It has also given rise to many new problems before us. There are many such crimes, including crimes committed through internet, including cyber terrorism, fraud, interference in people's privacy, child pornography, etc., which have become a challenge for the civilized society. Therefore, a strong and effective cyber law is necessary to regulate cyberspace. Today, many crimes are being committed through computers and internet, such as EFT fraud, credit card fraud, online gambling, virus attack, webjacking, pornography, salami attacks, counterfeiting, email spoofing, denial of service attacks, cyber defamation. cyber terrorism, cyber attacks, privacy violations, child pornography, etc. Today, countless crimes can be easily committed. Today, countless crimes can be easily committed using the internet. Some of the main ones are cyber crimes against individuals, cyber crimes against property, cyber crime against the government, cyber crime against a person, cyber stalking, theft of secret information and data, transmission of obscene material, unauthorized torture, unauthorized withdrawal of funds from financial institutions, copyright infringement, broadcasting of harmful programs, violation of privacy laws, hacking of government websites, cyber extortion, computer virus, impersonation, logic web, spamming, email bombing, Trojan horse, and cyber terrorism, etc. To prevent all these cyber crimes, an effective and powerful cyber law is necessary. Without effective cyber law, the use of internet and cyberspace is no longer free from danger. Thus today, as much as there is a need for the internet and cyberspace, there is an equal need for a cyber law to regulate their use. Therefore, an effective cyber method is not only necessary but inevitable today. What's the importance of cyber law in today's highly digitalized world? The importance of cyber law is increasing due to the following reasons. One is the digitalization of every work or service is increasing. Cyber crimes are also increasing in proportion. Therefore, cyber law is necessary to stop crimes. Two is all companies, whether small or big, depend on their computer networks. These companies keep their valuable data in electronic form. Therefore, effective cyber law is important for their security. Third is many forms related to government departments including income tax returns, company law forms, etc. are now filled electronically. Their security and privacy is not possible without strong and effective cyber laws. Today, credit cards and debit cards are being used extensively for shopping. In this, the possibility of fraud remains equal. Therefore, effective cyber law is indispensable to protect consumers from fraud. Today, most of the people in the country use mobile, email, SMS for communication, depend on etc. Therefore, effective cyber law is also important to protect their right to privacy. Today, even in cases of non-cyber crimes, important evidence is collected from electronic devices like computers, mobile phones, etc. It is difficult to collect evidence of divorce, murder, kidnapping, organized crime, drug trade, fake currency, conduct of terrorist incidents, etc., without the help of computers, mobile phones, etc. Therefore, effective cyber law is necessary for their regulation also. Today, most of the money transaction activities are being conducted through internet, World Wide Web and cyberspace. They are also being misused in large quantities. Hence, cyber law is necessary to regulate them. Thus, as the use of internet and cyberspace is increasing in our lives, effective cyber laws are also becoming necessary and important for us. let us discuss jurisprudence, important legal terms that is being explained. Let us explain the definition of jurisprudence as defined by various jurists. Let us discuss the nature and importance of jurisprudence. Jurisprudence is a formal science of positive law. Let us critically examine this definition of jurisprudence given by Holland. Jurisprudence is the philosophy of positive law. Let us discuss critically the definition of Austin. Jurisprudence is the lawyer's extra version. Julius Stone. Let us explain and analyze this definition. Jurisprudence is the eye of law. Next, let us explain the importance of jurisprudence looking to the present scenario. The word Vidhi Shastra is derived from two Latin words, juris and prudentia. The word juris refers to method, while the word prudentia means knowledge. Thus, literal meaning should be called knowledge of law. Knowledge of law means jurisprudence. But in reality, it is not just the knowledge of the method, but the systematic knowledge of the method. Systematic knowledge of the method. That is why the famous jurist Saman has defined the science of law as law. Here, science means the systematic study of the subject. According to Modi, the ultimate goal of jurisprudence is generally the same as that of any other science. This is the reason that the discipline is called micro and systematic study of the principles of law. The word law refers to such rules which control the conduct of human beings in society. While living in the society, one has to travel through various aspects of life. In this venture, we come in contact with other people. On several occasions, there is a possibility of a conflict of interest in the interest of other members of society. Therefore, if the necessary control is not kept on the conduct of human beings, then there is a tendency to spend disorderly or independent life, which can be a hindrance to the progress of society. This is the reason that through state law, local control is kept in various areas of human life so that they can progress by staying in the society. In its definition, different legalists have given different definitions of jurisprudence. The famous Roman jurist Alpine, in his treatise called Digest, has called jurisprudence the science of ancient unfair. The famous philosopher Cicero gave the definition of jurisprudence, where it is philosophical side of knowledge. According to Saman, in broad sense, He means the science of science. Under all legal principles are systematically studied by civil law. He means that particular law which is applied by a country towards its inhabitants and whom the citizens, lawyers and courts of their country are bound to believe. Thus, according to the law, jurisprudence is the science of the laws which the courts apply. It is clear opinion of the Samad that in law the particular method is not studied, but the fundamental principles of the method are studied in a systematic order of reason, which is necessary to transform a subject into scripture. It is noteworthy that from this point of view, the definition of appears to be much simpler, clearer, and practical than other definitions. John Anglo-Austin, the famous Anglo law scribe, has called jurisprudence the philosophy of the actual law. Professor Julius Stone has described jurisprudence as a subversive expression of lawyers. This means that on the basis of other sources of current knowledge, what the advocates test the concept, ideals and practices of the law can be called the subject matter of jurisprudence. Holland has defined jurisprudence as the formal science of real law. Adopting a pragmatic approach towards this subject, he has considered the scriptures related to the prevailing rules, ideas, and reforms of the law. His view is that jurisprudence relates more to human behavior governed by the laws of law than to physical rules. It is noteworthy that the actual method used in the definition of jurisprudence given by Holland has a lot in common with the civil law used in the definition of society. Real law refers to such laws regulating current relations which are made by the state and enforced by the courts. Only such rules have been called practical by someone. Holland has called jurisprudence formal science because this scripture does not contain the study of those rules which have themselves originated from earthly relations, but in it relations are studied which are arranged in order by varied rules. Thus, the science is different from physical science. According to Professor Gray, jurisprudence is a science of law under which the orderly and systematic rules and principles embedded in them are studied by the courts. According to Patton, Vidhi Shastra is the study of different types of method. Allen has called jurisprudence a scientific analysis of the fundamental principles of law. Daesh and Hedges have accepted legal education as legal training and education. The legalist, the famous legalist Lee is of the view that jurisprudence is an idea which seeks to ascertain the fundamental principles and whose expression is famous in the method. Professor Caton considered jurisprudence to be merely a knowledge of the general principles of law. According to them, this scripture paves the way for detailed study of the general principles of law and their systematic system. Vinogradov has given the definition of jurisprudence by adopting a historical approach to the method. According to him, jurisprudence has its origins in the inequalities found in its actual method in the history of various nations. The purpose of which is to find out the general principles contained in legal acts and judicial decisions. Sociological pathology, Dean Rasco Pound has given the definition of jurisprudence, saying that jurisprudence is knowledge of law. Here, the meaning of the law is in the judicial sense. That is, Vidhi Shastra is compilation of such principles, those built for establishment of justice and which are accepted and enforced by the courts. Last propound has laid special emphasis on the social aspect of jurisprudence. Justice has its own importance in human life. In a society without justice, it will become difficult to sustain human life. Therefore, considering the legal system as important, Roscoe Pound has considered it to be the science of the principles that establish justice. It is clear from the statement that different justices have explained different aspects of jurisprudence. However, two conclusions can be drawn from these definitions. First, despite the differences in the subject of the concept of jurisprudence, almost everyone accepts that the law is science of law. Secondly, all legalists accept that it is appropriate to call the study of the basic concept of law a legal discipline. This means that the method of learning is not merely a study of knowledge. This means that the method of learning is not merely a study or knowledge, rather it is a science of law. In order to keep the branch of any knowledge in the category of science, it is necessary to present it in a systematic manner. The subject matter of jurisprudence is the law and various concepts related to it. The basic purpose of discipline is to study the origin and progress, development, and function of the law. In other words, the nature of the method and its various elements are discussed under this description, and its various sources and objectives are studied. What's the nature of jurisprudence? The subject matter of jurisprudence is different from other subjects of law, just like contract law, tort law, penal procedure, trust, income tax, etc. are used to solve problems in specific circumstances. Jurisprudence is not used in this way. This is why there is uniformity in the book of law related to other laws, whatever may be the views of the authors. The content of the enacted law will be the same. But due to non-enactment of the law, legalists have the freedom to present their subject matter according to their personal views. Concepts related to various laws are discussed under jurisprudence, in which the general and broad form of rights, liability, ownership, occupation, legal personality, intention, neglect, etc. are represented. What is jurisprudence? What is justification for placing the discipline in the category of science? Many scholars have defined the science of law as law. Hence, the question that arises is whether the discipline can be kept in category of science. According to various definitions of jurisprudence, aspects related to law can be studied in a systematic way. Practices and social and moral beliefs have no place in jurisprudence, as stated by Austin and subsequent legislatures. However, it tarnishes the concept of the method. Therefore, historic thinkers represented the law as the swan order so that certainty, rationality, and practicality remain in it, which is the key element of any branch of science. This method, adopted towards the study of jurisprudence, stands by bringing it very close to science. In this way, credit should be given to the orthodox jurisprudence for placing science in the category of science. Later, Eyring, Ehrlich, Max Weber, and Holmes, etc., carried forward this ideology and portrayed the law as a powerful medium of social change. It is only appropriate to keep it in the category of science because of its positive attitude towards jurisprudence. The field of jurisprudence, like the field of jurisprudence, legalists, legalists have expressed different views regarding the area of jurisprudence. Kelson kept jurisprudence separate from ethics and sociology. The legal practitioners of the Anglo branch of analytical jurisprudence thought it appropriate to confine the study to analytical jurisprudence. According to Dean Rasco Pound, the field of jurisprudence should be confined to the study of deterministic method only. By definitive method, they mean the method which is applied by the sovereign ruler of the state to the citizens. Thus, according to Austin, the purpose of jurisprudence is not to discuss the merits of the law on the basis of utility, but that its relation should be limited only to the study of law enforced by the state. According to Samad, the field of jurisprudence is limited to the study of civil law. By civil law, they mean the basic principles of civil law of different countries. Similarly, other scholars have expressed different views towards this scripture, but it is worth remembering that due to the method having a close relation with the social life of human beings, it is not appropriate to divide its various concepts into separate parts. Along with social development and changes, the concept of law changes as a result. The scope of the method also expands. Therefore, under jurisprudence, historical, comparative, analytical, philosophical, medical related to anthropological, etc., are included in all. Such scripture whose purpose is to study the concepts and principles related to law. This is the reason that the field of legal science is very wide and wide. What's the importance of jurisprudence? Some legalists have called jurisprudence as the eye of the law. That is, the study of law has the same importance as the law for the human body, just as a man's life without eyes is dark. Similarly, the study of the method remains incomplete and unclear without knowledge of jurisprudence. Jurisprudence is the key to the method that travels, the secrets hidden within it. In other words, it would be appropriate to do the method of studying the method which does the grammar for studying the language. This does not mean that the study of law is beneficial only for students of law, not for other classes. In fact, for other sections of society, such as lawyers, judges, politicians, and legislators, administrators, etc., studying law is as important as it is for students of law. Therefore, it is not a doubt that jurisprudence has great importance in practical life. People who study law get to know the basic principles of various methods of law from the law itself. Similarly, this study gives advocates and legislators an accurate knowledge of the and technical terms used under the law so that they can understand the correct form of the method and advocate accordingly or make efficient methods. The study of this scripture is also necessary for judges, politicians, and ordinary people due to knowledge of the basic principles of law. Judges have to give their decisions according to the prevailing law. Therefore, without adequate knowledge of jurisprudence, it would be difficult to do this work. Similarly, to make politicians aware of policy-related ideologies, they should have knowledge of the law so that they can adapt their policies according to the law. Due to the direct relation of the law with human development, it becomes necessary to change the principles of law along with the progress of society. This is the reason that in the present times special importance can be given to the sociological aspect of jurisprudence. There is no doubt that in the present time the importance of studying law is increasing continuously. In order to make our ideas in line with social goals, we have to understand the standard social values through jurisprudence and adapt our behavior to them. In the present era, special emphasis will have to be given on the study of the functional aspect of the law in order to deal with the problems of poverty, population, public health, environment, etc., so that its utility can be increased in the society. The currently passed dowry prevention law in India, environment pollution preventive law, consumer protection law, and free legal aid system for the poor, etc., can be called precious states of functional legislation. In the context of Indian jurisprudence, it will suffice to mention that its main purpose is included in the Constitution of India. Providing social justice to the people is the main goal of the legal system of the current progressive countries. While ensuring the rule of law in the country, needless to say that India has achieved an unprecedented success in this. In this context, it is noteworthy that in the last 25 years, the judges of the Supreme Court of India have also tried their best to make the law an effective means of public interest using judicial action. These include former Chief Justice V.I. Gajendra Gadkar, P.N. Bhagwati, and former judges we are the contribution of Krishna Iyer has been particularly notable according to Justice Krishna Iyer. The purpose of the law should be a remove should be to remove the poverty, ignorance, and compulsion of the people of India so that the imagination of the welfare state required by the framers of the constitution can be realized. Dear friends, tomorrow we will define legislation. Transfer of property law. Now let us describe, define, explain what is in transfer of property law. Let us explain the notice as provided in Transfer of Property Act 1882. Define and distinguish between actual notice and constructive notice. What do you mean by notice? Let us explain the doctrine of notice with legal cases. What is notice? Information is a major principle of equity which controls transactions against conscience which have been recognized in various sections of the Act. For example, as per the provisions of Section 39, if any, such property is transferred from which a person has a right to receive maintenance, then in such a case the transfer will be liable for such amount only if he has a right to such maintenance. There was information at the times of transfer. In this way, the provisions described in Section 27 of the Conviction Act 1872 and Section 91 of the Trust Act 1882 can be given as examples. Similarly, information in other sections 40, 41, 43, 53, 53A of the Act is important. The definition of this word is given in the last paragraph of the section 3. In its definition, according to section 3 of the Act, a person is considered to be informed of a fact while he really knows that fact, or he would have known that fact if had not deliberately kept from doing such an investigation or such which he should have done or would not have neglected grossly. It is clear from these definitions of information that there are two types of information. One is actual notice and two is constructive notice. is actual notice? Actual information of a fact means information by which a person obtains real information of that fact. That is, a fact is the actual information by information to a person. Information about a fact has been given by the interested person during the conversation, which is a definite information and is related to the transaction. To report any fact in rumors or by unknown person is not known as real information. Actual information has the following elements. One is notice of certain facts. Under the Act, actual information is considered only when certain facts have been made known to a person. If the facts giving information are not certain, there it will not be legal information. If a person has received information about any facts indirectly or otherwise by broken words or by distorting the words, then it is not real information. To give information by a person interested in property or by transaction. If any information related to property is given by an unfamiliar person, it is not real information. For the actual information, the information or the fact is required to be given by someone who is interested in the property. The information should be related to the same transaction. In the context of the transaction in which the two parties are negotiating, it is necessary to give information about a fact in the context of the same transaction. If any information has been given regarding that property before the transaction, then it will not be considered as real information because the information given earlier can also be forgotten. Attention has been drawn to the information while giving the information to the person to whom the information is given. It is also necessary for the actual information that the person to whom the information is to be given while giving the notice of the person properly. While giving the notice of the person properly. While giving the information should be attractive. If the person receiving the information is not focused on information, then it will not be the actual information. Constructive notice. What is constructive notice in information? Information. A person does not know the fact of a fact. But if he tried to know about that fact or made little effort, that fact could come to his knowledge if the responsibility of getting information about that fact has been imposed on that particular person by contract law or equity. Then in such a situation the law assumes that he was aware of that fact, even if he did not have knowledge of that fact in reality. For it has been given the name of protected information. Protected information is a form of punishment for a person not performing his duty because in it, without knowing the fact of a particular person, the law assumes that he was aware of the fact, but this concept is done only when it is assumed that he would have had actual knowledge of those facts if he had conducted such an investigation. The information displayed in the information displayed is such a knowledge of a fact which the court accuses a person of as a concept, that he must have had knowledge of that fact, and this concept is so strong that it cannot be disfound. In his classes of physical information, the protected information as defined in Section 3 of the Transfer of Property Act is divided into the following five classes. That is, in the following five circumstances, the deemed information is considered. One is while deliberately refraining from investigating any fact, or two is on not knowing a fact due to gross negligence. Three, in relation to the documents to be compulsory, in relation to the document to be compulsorily registered, or in relation to the actual possession of immovable property, or regarding information to an owner's agent. Dear friends, next we will explain the immovable property as provided in Transfer of Property Act 1882. Family Law 1, Hindu Law. Who is Hindu? There was an era when the word Hindu was not used only for followers of one faith, but in a regional sense. All the people living in India were called Hindu. Gradually, Muslims arrived and they addressed the people living in the valley of river Sindh as Hindus. After After this, the word Hindu started being used only for those people who followed Hindu religion. Therefore, the word Hindu remained a symbol of only the followers of one faith. Today, it is difficult to define the word Hindu, and even after the codification of Hindu law, its definition has not been given. But law is practical subject. Hence, under the law, it has been told that on which person Hindu law is applicable, and on this basis where it can be said that the following person is a Hindu, that is, Hindu law applies to the following persons. One is who is Hindu, Buddhist, Jain or Sikh by religion. Two is persons who are the children of Hindu, Buddhist, Jain or Sikh parents or either of them. Three persons who are not Muslims, Christians, Parsis or Jews. Section 2 of the Hindu Marriage Act 1955, Hindu Succession Act 1956, Hindu Adoption and Maintenance Act 1956, and Section 3 of the Hindu Minority and Guardianship Act 1956. Let's explain. The Mitakshara School of Hindu Law. The Mitakshara branch of Hindu law was named after Vijayaneshwar's commentary Mitakshara. Its jurisdiction is entire India except Assam. Mitakshara recognizes succession on the basis of kinship by blood. This is the fundamental essence of the present Hindu law, but in this branch the other rules have been disrupted by two roles. One is exclusion of women from succession, and two is preference of clan over brothers. Similarly, Mitakshara branch propounded the birthright of son, grandson, and great grandson in a joint family. That is, as soon as they are born, the son, the grandson, and great grandson get interested in the property of the joint family. This means that with the birth of a son, he becomes a co-partner, but before partition, no co-partner can say that he is a partner in a particular part of the property. His interest is fluctuating, that is, it decreases with the birth of a co-partner and increases with the death of a co-partner. Apart from this, generally no co-partner, whether father or Karta, can alienate the co-partner property. Mitakshara branch has many sub-branches: Mithila, Varanasi, Bombay, and Dravid. What are the powers of Karta in a joint Hindu family? The joint Hindu family is a patriarchal body where the head of the family is called the Karta or Karta. The Karta is the senior most male member of the family who acts as the representative of the family and acts on behalf of the family. There is a trust relationship between the Karta and the other members of the family because every family needs a head member who can look after the welfare of the minor members and women in the joint Hindu family. The position of the Karta in a joint Hindu family is unique. The Karta takes care of the entire family and its property, and the decision given by the Karta is mandatory to be followed by the members of the Hindu joint family. In a Hindu joint family, no one is equal to the Karta. The powers and status of a Karta are broader than those of any member of a Hindu joint family. No one among the other members of the joint family can be compared with the Karta. Generally, the senior most member of a joint Hindu family is the Karta, but a junior member can also be the Karta if the other members agree. According to theology, if there is no male member in the family or the person in a minor, then the woman can also be the Karta. The powers of the Karta are as follows. The Karta of a joint family, Hindu family, can do the following at his direction, at his discretion, without the consent of other members. One is he can manage the property and business etc. of the joint Hindu family. He adjusts the income and expenditure of the family to represent the family in legal, religious, and social matters, to compromise or hand over disputes to arbitrators, in family related disputes, taking any loan, etc., or entering into any contracts, transfer of joint family property in certain circumstances. What is religion? Religion means that which is worth holding. According to Manu, the rules accepted by accomplished and virtuous people in the Vedas are dharma, which is devoid of hatred and abnormal affection. Vedas, Smriti, good conduct, and good soul are the four characteristics of dharma. Dharma is a symbol of duty. Karma is dharma. It is said in our Hindu religion, what is same-sex marriage? Same-sex marriage refers to the legal and social recognition of marriage between persons of the same sex or sexual orientation. In such marriages, two persons of the same sex come together in a formal union with the same legal rights and responsibilities as opposite sex couples. What is live-in relationship? Live-in relationship is an arrangement in which two people live together without being married and have an emotional and sexual relationship with each other. This relationship is affectionate and can sometimes last for a long time or even be permanent. In India, following are the rules related to the living relationships. One is to live in relationship, both the people should be above 18 years of age. Two is to live in a living relationship, neither of the two people should be married before. Three is both the people need to get registered. For this, an application has to be submitted to the district registrar. There should be a reasonable time period between the two people. Both people should jointly use the things in the same house. Both people must take financial responsibilities. Inheritance is never in obedience. Inheritance is never in abeyance. Let us explain this statement and state the exceptions, if any. Inheritance is never be abeyance. According to this general rule of Hindu inheritance law, as soon as the owner of a property dies, his property goes to his heirs. The reason for this is that no property can remain without an owner because according to Hindu jurisprudence, only that things is called property which has an owner. According to Hindu law, after the death of the father, his son can inherit the property in place of the father or claim his share in the joint family. It is worth remembering that the rule of inheritance applies only to those people who are born and not on the dead. Inheritance means receiving property by a legitimate descendant here. Thus, it is clear that a dead person cannot inherit the property. If a child is in the womb of the mother, then he is considered alive for inheritance. Tagore v. Tagore, IASC 47. Inheritance does not depend on the will of any particular person. Law of inheritance is a state. This rule is not made for the benefit of a single person, but is made because of public policy. From this, it is clear that the inheritance which a person wants by way of gift cannot be made, and the inheritance should be in the form prescribed by law. In its exceptions, it is a general rule that once the property is vested, it cannot be taken away. After the death of the deceased, when his property is received by his immediate heir, then the birth of any immediate heir after that cannot harm that property. There are following two exceptions to this rule in Hindu law. When the property passes to a widow, and she adopts a child in the name of the husband. When the preferential heir is born, etc., a boy or a girl is born who was already in the womb before the death of the owner of the property. Conclusion. In short, we can say that the right of inheritance in the property arises immediately after the death of the owner. How can a gift be made to an unborn person? Gift to unborn person is gift to unborn person in ancient Hindu law. Donation could not be given to an unborn person, but according to section 13 to 16 of the Transfer of Property Act 1882, now a gift can be made in favor of an unborn person under the following condition. A donation cannot be made directly by the donor to an unborn person. The life interest in the property must be given to someone else before he can make the donation. A donation to an unborn person will be valid only if he is given an absolute remainder, interest, that is, interest, etc. He cannot be given a living interest. A donation made in contravention of the rule against perpetuitized shall be void. If a donation made to an unborn person is void by reason of the violation of the shared rules, then the donation effected after such donation will also be void. What is Uniform Civil Courts? Our Constitution prohibits discrimination on the basis of caste, religion, sex, gender, etc. Uniform Civil Court is the promoter of this concept. According to this, a uniform law should be made for all religions in matters of marriage, divorce, etc. Article 44 of the Constitution states that the state shall endeavour to secure for the citizens a uniform civil court throughout the territory of India. In fact, the main objective of the Uniform Civil Code is to eliminate discrimination on the basis of caste, religion, and sex. What is the meaning of usage? How many types are there? And tell its essential elements. Usage is a rule of conduct which the governed follow voluntarily. It is of three types. One is locate, two is class, and three is family usage. Its essential elements are as follows: one is antiquity, two is continuity, three is non-resistance, four is certainty, five is rationality, six is compatibility with policy, seven is universality, and eight is mandatory observations. Mandatory observance. What is Smriti? The literal meaning of the word Smriti is that has been remembered. Our sagas remember the divine voice and compiled this divine voice in the Vedas. Even then, a lot remained in their memory. It is believed that Smriti are based on the memories of sagas and saints. Smriti is divided into two parts in prose. Dharma Sutra in poetry, Dharma Shastra. Dharma Sutra is related to the rules and principles of law. The era or period of Dharma Sutras merged with the era period of Dharma Shastra. Later on, a well-organized form of law is found in Dharma Shastra. What is meant by Shruti in Hindu law? The word Shruti literally means what was heard, the voice of God. which our Shagas gave us for listening is called Shruti. Another name for Shruti is Vedas, and it is the voice of God in the Vedas. There are four types of Vedas: Rig Veda, Yajurveda, Samveda, and Atharvaveda. Vedas are the source of all knowledge, hence Vedas are the original source of all rules and regulations, and thus Hindu regulation is divine regulation, divine legislation. What is the right of minor proportional power to enforce partition? Minor proportioner has the right to partition. Minor proportioner also has the right to partition like other proportioners. His minority is not a hindrance in this. Minor proportioners can get partition done only by filing a suit for partition in the court. The suit can be filed on his behalf by his litigation. Friends, later on we will continue family law. भारतीय न्याय संहिता 2023. Bharatiya Nyaya Sanhita 2023. Let's explain the main characteristics of Bharatiya Nyaya Sanhita 2023. Bharatiya Nyaya Sanhita 2023 has replaced the Indian Penal Code 1860. The Indian Penal Code 1860 remained in force for about 150 years. It has been an important achievement of the British government, or say Macaulay. Many amendments were also made in it from time to time. In the last 150 years, circumstances changed rapidly and social changes also took place. The nature and types of crimes also changed. New crimes started being committed, such as organized crime, terrorism, cybercrime, etc. The attitude of our top courts also changed. It declared adultery, unnatural crimes, etc. as unconstitutional. As a result, the need for a new code in place of the Indian Penal Code 1860 started being felt. The Indian Penal Code 2023 is the culmination of this. It was implemented all over India from July 1, 2024. What are the features of the new code? The Indian Judicial Code contains many features in its shell, such as one is the first feature is the change in its name or title. The name of the previous code was Indian Penal Code. While this code had been named Bharatiya Nyaya Sanhita, to which there are a total of 20 chapters and 358 sections in this code, every act and omission contrary to the provisions of the code has been declared punishable. The word crime has been given a wide meaning in it. Every act done outside India has been included under crime, which would have been punishable under this code if it had been done in India. A new chapter of definition has been added to this code. Definitions of A total of 27 words have been given in its section 2. In the previous card, these words were defined in different sections. This chapter was named General Explanation, which included section 6 to 52a. The definition of gender includes transgender, and it has been given the same meaning as in clause 1 of section 2 of the Transgender Person Protection of Rights Act 2019. Act 2019. Section 4 describes different types of punishments. Its clause 5 also includes community service. Section 5 provides for commutation of death sentence to life imprisonment in which the consent of the offender is not considered necessary. In calculating the fractions of sentence period, life imprisonment will be deemed to be equivalent to 20 years of imprisonment. Section 6, where the offence is punishable with fine only and default is made in payment of fine. Provision has been made under clause 5 of section 8 for award of imprisonment for the following terms. In case of fine not exceeding rupees 5,000, imprisonment for a term not exceeding 2 months. In case of fine not exceeding rupees 10,000, imprisonment for a term not exceeding 4 months. In other case, imprisonment for a term not exceeding 1 year. In this court, the following crimes have been kept under the same chapter, etc. Chapter 4, whereas these crimes were kept under different chapters in the previous court, such as abatement, chapter 5, criminal conspiracy, chapter 5a, and attempt, chapter 23. Section 69 of the court declares sexual intercourse done through deceptive means a punishable offense. The following are included in deceptive means. One is giving assurance of employment or promotion. Two is inducement. Three is concealing identity. Four is giving false promise of marriage. It is worth mentioning here that in recent times, case of sexual intercourse with a woman by giving false promise or assurance of marriage have started coming before the courts, about which the courts have been expressing their opinion from time to time. In this regard, State of Uttar Pradesh versus Noshad AIR 2014 Section 384 is a citable case. In this, the Supreme Court held that if the accused had sexual intercourse with the prosecutrix by assuring her that he will marry her, the prosecutrix becomes pregnant and the accused refuses to marry, then it will not be considered as the independent consent of the prosecutrix and the accused will be liable for punishment. Another similar case is Anurag Soni versus State of Chhattisgarh, AIR 2019, SC 1857. In this, the accused had sexual intercourse with the prosecutrix several times by assuring her of marriage. The prosecutrix did not oppose the intercourse on the assurance of marriage. The court considered it a punishable offense because the consent of the prosecutrix was under illusion and delusion. Now this controversial situation is over. This is an important feature of this court. In this court, disclosing the identity of the victim of the crime of rape has been declared a punishable offense. Disclosure of identity includes both printing and publication. In Chapter 5 of this court, unnatural offenses have not Natural offences have not been included in sexual offences. Unnatural crimes mainly include sodomy, oral sex, sex with animal, etc. It is worth mentioning here that Section 377 related to unnatural crime was declared illegal and unconstitutional by the Supreme Court In the case of Navteej Singh versus Union of India AIR 2018 SC 4321. Adultery has also not been included in this court. It is worth mentioning here that section 497 related to adultery has been declared illegal and unconstitutional by the Supreme Court in the case of Joseph Shine versus Union of India AIR 2018 Act AIR 2018 SC 4898. Crimes related to outraising the modesty of a woman have been included in Section 73 to 78. Section 74 gives the same definition of gender harassment as given by the Supreme Court in the case of Vishakha versus State of Rajasthan, AIR 1997 SC 3011. Attempt to commit suicide has not been included in the new code. Section 109, 110 and 111 of the code add that the following new offences respectively. Organized crime, petty organized crime and organized crime in general, and terrorist act. The following are the included in organized crimes: violence, threat of violence, intimidation, harassment, corruption, kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic crimes, cyber crimes, arms trafficking, prostitution, ransom, etc. This is an important achievement of the new court. For some time now, there has been a continuous increase in land mafia, contract killing, cybercrime, etc. Keeping this in view, these crimes have been given a place in the new code. Clause 4 of sections 115 of the code makes it a punishable offense to cause hurt to any person by a group on the basis of his race, caste, sex, place of birth, language, personal belief, etc. This is a new provision which was not there in the pre-code. An important feature of the new code is that section 124K of the offense of sedition has been removed from the code. Sedition has been a subject of discussion for a long time, and this is the reason why it has not been given a place in the new code. In place of sedition, section 150 of the new code makes acts that endanger the sovereignty, unity and integrity of India a punishable offense. Section 302 of the code makes provisions for the offense of snatching. The crimes mentioned in the remaining chapters have been kept unchanged, with minor changes or modifications. Overall, the new Indian Judicial Code is before us in a completely new environment. In essence, it can be said that every possible effort has been made to make this code relevant to the times, or in other words, to the country, time and circumstances. Dear friends, tomorrow we will discuss what are the different stages of a crime. Is preparation to commit an offence punishably under the Indian Penal Code? If so, what are those offences? An accused is not liable for a crime if lie only prepares to commit it, but he is liable if attempts its commission. Discussed with illustration, also state the exceptions to this rule under the Indian Penal Code. In what cases mere preparation is punishable under the Indian Penal Code? What are the different stages in the commission of crime? When is preparation punishable? Company Law and the Competition Act 2002. Define a company and explain its essential characteristics. Let us define company, discuss the various characteristics of a company under the company law. The company is an artificial person created by law with perpetual succession and common seat. Let us explain this statement and describe the basic features of a company. A company is a legal person just as much as an individual but with no physical existence. Let us explain this statement, discuss characteristics of company. Company is composed of two words. Means together, pains means bread equal to company. In ancient times, traders used to trade commercial deals while at the same time eating food due to which their business organization was named company. Initially, it could be formed for any purpose, but in the long run, it was used for groups which were organized for economic purpose. According to the definition of company given in Section 220 of the Companies Act 2013, the company is from the company incorporated under this Act or the previous company law. Lord Lindley has written defining the company. A company is a body of many individuals who deposit the amount of money or equivalent to use it in a joint fund for use for a certain collective purpose. This type of joint fund is declared in the currency and it is the company's capital. The person who contributes in it is called a member. The ratio of capital which each member officer is called a fraction. According to American Chief Justice Marshall, a corporation is an artificial person. It is invisible and intangible and only exists in the eyes of the law. Because of being created by law, there are attributes in it which provide the legislation that creates them in a clear form or which is very essential for their existence. Its key features are on the basis of which the continuity of group of continuous person is irreversible. It is believed that one can walk like a person. In England, the company is used as legal personality, whose existence is distinct from its members and which is unaffected by the life death of its members. Company in India has been defined in Section 220 and Section 221 and 222 of the Companies Act 2013. According to Section 220, company means a company incorporated under the Act or any other company law for the time being. In the case of a company limited by guarantee, further as per Section 221, company means a company in which the liability of its members is limited to the amount prescribed in its limit rule, which they have agreed to pay to the company on the winding up of the company. In the case of a company limited by shares. Again, according to Section 222, it is such a company whose liability of the members is limited in proportion to their shares, that is, in the event of the company's winding up, the liability of its members is limited to the unpaid portion of the shareholders' purchase only. Such acts relating to companies which were in costs before the Act 1866, the Indian Companies Act 1866, the Indian Companies Act 1882, the Indian Companies Act 1913, the ordinance related to the registration of transport companies 1942, etc. Thus, under the Companies Act 1956, company has not been defined, but it has been told that what will come under the company essential signs or features: voluntary union, independent legal identity, permanent succession, general currency, limited liability, transfer of fraction, to be settled citizenship. Information technology law that we have discussed earlier. Now, principle of taxation law. Let us explain from Tax Act 1961. Tax assessment year. Assessment year. Section 29. According to the above section of the Income Tax Act, the assessment year refers to the time of 12 months, which starts on 1st April each year. This year, the name of the income tax year is also given. Thus, this year is the financial year, which starts on 1st July and ends on 31 March. For example, the tax assessment year 2005-6 is the year that begins on April 1, 2005 and ends on March 31, 2006. The financial year in which the tax is levied, the financial year in which the tax is levied is called the assessment year. The tax rates are fixed every year by the Finance Act. The year which began on 1st April 2005 and ended on 31st March 2006 will call its taxation 2005 and 6, in which tax will be levied in relation to the income of last year 2005 to 6. Previous year, Section 3, according to the above section of the Income Tax Act, the financial year immediately before the assessment year is called the last year. For example, tax assessment, the last year related to the year 2005-6 will be from April 1, 2004 to 31st March 2005. In the case of new business, the date of the new business commenced or the date on which the new instrument of income comes into being. The data from which the data of expiry of the financial year will be considered as the last year. For example, if the taxpayer starts his business on October 1, 2004, then his last year will be from October 1, 2004 to March 31, 2005. General rule: the income of the previous year is charged only in the respective taxation year. Exceptions to the rule: generally the income of the tax year is taxed only in the year of assessment. But the exception is in which tax is found only in the year of earning. One is on income from trade by sea, ship of non-residents, section 172. On the income of person leaving India with the intention of not returning, section 174. Taxation of association of individuals, groups of persons or artificial judicial persons created for a specific event or purpose, section 74A. Transfer of property to save tax, section 175. In case of trade off, section 176. Next, tomorrow we will explain the income Income Tax Act 1961, partly agricultural income, agriculture income. Labor and industrial law. Labor and industrial laws. Let us explain the term factory. What special provisions have been made for employment of women and young persons in the Factories Act 1948. Factories have an important place in the field of industry. This is the enterprise where various production activities take place. Factories are at the places of employment. The passing of the Factories Act 1948 is indicative of the importance. In its definition, the word factory has been defined in Section 2M of the Factories Act 1948. According to this, factory means any premises, including the precedents thereof, where on 10 or more workers are working or were working on any day of the preceding 12 months, and in any part of which a manufacturing process is being carried on with the aid of power of ordinarily so carried on, or where on 20 or more workers are working or were working on any day of the preceding 12 months, and in any part of which a manufacturing process is being carried on without the aid of power or is ordinarily so carried on, but does not include a mine subject to the operation of the Mines Act 1952, 35 of 1952, or mobile until belonging to the armed forces of the Union, railway running shed or a hotel, restaurant or eating place. Two clarifications have also been added to these definitions. According to the first clarification, while calculating the number of workers for the purpose of definition of factory, all the workers involved in different groups and shifts on any day shall be included. According to the second explanation, for the purpose of this definition, the mere fact that any electronic data processing unit or computer unit has been installed in any premises or any part thereof will not make it a factory if the manufacturing process is not being carried on in that premises or any part of thereof. From the above definition of factory, its following elements become clear. One is premises and precincts. The word premises is important for factory, that is, premises is a sign or indicator of a factory. It may or may not have precincts, that is, any open space can also be a factory. In case of State of Bombay versus Ardeshir Harmosji Vivadiwala 1956 to LLG 26. Any open place had been considered as a factory for preparing salt, that is, the land on which the process of manufacturing salt is carried out, can be called a factory. As far as the boundary is concerned, the places surrounded by wall or fence is called a precincts. Number of workers, the second essential element of a factory is number of workers. For any premises to be considered as a factory, it is necessary to have a specified number of workers in it. If the manufacturing process is carried on by power at any premises, it must employ 10 or more workers during the preceding 12 months, and if the manufacturing process is carried out without power in any premises, it must have employed 20 or more workers in the last 12 months. In the case of Re K. V. Sharma, AIR 1953, Madras 269, considering the persons employed in the production of films also as workers, it has been said that the word worker also includes intellectual, spiritual, and artistic artist. One such case is that of in Re Sokalingam, AIR 1954, Madras 324, in which such premises have been considered as factory in which 20 persons were employed. One of them looked after supervisory work, the second one was an apprenticeship, and cigarettes were produced in that premises. Operation of manufacturing process. The third essential element of a factory is that the manufacturing process should be conducted within the premises. In fact, this is the most important element in the case of New Taj Mahal Cafe Limited, Bangalore versus Inspector of Factories, Bangalore 1956, 1 LLJ 273. It has been said that more use of power in the factory premises is not sufficient. Such power must be used for the manufacturing process. If any manufacturing process is not going on in any premises, then it cannot be called a factory. Workman daily lecture supply undertaking versus management AIR 1973 SC 365. Before proceeding further, it would be appropriate to understand the word manufacturing process here. According to section 2K of the Act, manufacturing process means any process in relation to the following. Manufacturing process means any process for making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing, or otherwise treating or adapting any article or substance with a view to its use, sale, transport, delivery, or disposal, etc., or pumping oil, water, sewage, or any other substances, or generating, transforming, or transmitting power, or composing types for printing, printing by letter, flash, lithography, gravure, or other similar process, or bookbinding, etc., constructing, reconstructing, repairing, refitting, finishing or breaking of ships or vessels, etc., preserving or storing any article in cold storage, according to the above definition, running a canteen by a cinema house is not a factory, even if only 20 workers work in it. In the provision to Section 2E of the Act, hotels, restaurants, meeting places, etc., have not been included in the definition of factory. Film studio is a factory. In the case of Re KVV Sharma, year 1953, Madras 269, the film studio has been considered as a factory since the person employed in the production of films are workers, and this work falls within the scope of the manufacturing process. Similarly, is the land on which the process of manufacturing salt is carried out, a factory, even if it is an open space. State of Bombay versus Ardeshir Harmosh G 1956 LLG 26 Employment of Women. No separate provision has been made in the Factories Act regarding employment of women. Some specific provisions regarding employment of women have been made in various sections, such as separate toilets and urinals will be provided in the factory premises for women workers, and they will be clearly marked. Section 19(1)(b). A woman worker shall not be employed in the main part of the moving machinery while it is in motion or in cleaning or oiling any moving machinery. Section 22(2). No woman shall be employed to press cotton in any part of any factory where a cotton gin is in operation. Section 27. No woman shall be employed in any factory to lift, carry, or move such heavy loads as to likely to cause her injury. Section 34. In factories, women workers will be provided separate washing facilities from men and with proper curtains. Section 42 1b. In every factory in which more than 30 women are ordinarily employed, there shall be maintained a room suitable for the use of such women and children under 6 years of age. Such children will be looked after by trained women. Mothers will also be provided facilities to feed milk to their children. Section 48. No adult worker shall be required to work more than 9 hours in a factory in any one day, but the working hours may be increased with the prior approval of the Chief Inspector. Section 54. But this system will not apply to women workers. Section 66 1a. Where a building or premises is made available by the owner of a factory and for the same it is necessary to fulfill the statutory provisions of sections 42 to 48 regarding exemption of tax. UTAX Germans Limited versus State of Kerala, AIR 2009 NOC 1741 Kerala. No female workers shall be expected or allowed to work in any factory during the period after 6 a.m. to 7 p.m. Section 66 1b. Any adolescent female worker who has not attained the age of 17 years but has obtained a fitness certificate shall not be allowed to work in the factory at any time except between 6 a.m. and 7 p.m. Section 71a. No female child shall be required or permitted to work in a factory at any time except between the hours of 8 a.m. and 7 p.m. Section 71.5. Thus, many important provisions have been made in the Factories Act 1948 regarding the employment of women. Employment of minors. Many provisions have also been made in the Factories Act 1948 regarding the employment of minor persons. Before proceeding further, it would be appropriate to tell here who are adults, teenagers and children for the purposes of this Act. According to Section 2A, adult means a person who has completed 18 years of age. According to Section 2B, juvenile means a person who has completed 15 years of age but has not completed 18 years of age. According to Section 2C, child means a person who has not completed 15 years of age. The following provisions have been made in Section 67 to 55 of the Factories Act regarding the employment of minor person. One is no child who has not completed 14 years of age shall be employed or permitted to work in any factory. Section 67. No child who has completed 14 years of age or is a juvenile shall be employed in any factory unless a certificate of suitability in respect of him is obtained. A token to this effect will also have to be kept for such a child or adolescent. Section 68. The child or adolescent may be employed in a factory only if he is issued a certificate of fitness by a certified surgeon. Section 69. No juvenile who has not completed the age of 17 years but has been issued a certificate of fitness shall be employed in any factory during any period other than the period between 6 a.m. to 7 p.m. Section 71a. No child shall be employed for more than 4.5 hours in a day, shall not be completed shall not be employed during the period between 10 p.m. to 6 a.m. Section 21 1. In relation to the employment of children, only two shifts can be run in a day. No child will be able to work in one or more shifts, and the duration of one shift will not be more than 5 hours. Section 71 2. No child who has worked in any factory shall be employed in any other factory on the same day. Section 71 4. In every factory in which children are employed, information regarding their working hours shall be clearly indicated. Section 72. A register of child workers shall be maintained in every factory in which the following information shall be recorded: name of the child worker working in the factory, the nature of his work shift, number of certificates of stability, etc. Section 73. Child workers mentioned in Section 73 cannot be employed in any other factory. Section 74. Where a minor worker obtained through a fitness certificate or without a fitness certificate is not, in the opinion of the factory inspector, fit to work in a factory, it shall be the duty of the factory manager to get such a worker certified by a surgeon and do not hire him until such tests are done. Section 75. Thus, many important provisions have been made in the Factories Act regarding the employment of person, minor persons. Dear friends, tomorrow we will discuss what are the provisions under the Factories Act 1948 regarding the health and welfare of workers. Now next is labor and industrial law. Labor and industrial law. One, what do you understand by the term labor welfare? Discuss the nature and scope of the labor welfare. The concept of labor welfare is flexible and elastic and differs widely with time, degree of industrialization, and social progress prevailing in particular country. Let us evaluate and discuss the concept of labor welfare in the light of above or these statements. There are two important elements of industrial development: labor and capital. Both are dependent on each other. Economic development is possible not only with labor, also with capital. It is said that the new construction of the country depends on capital as well as labor. Hence, labor cannot be ignored. The source of labor is the working class. The labor class is considered an important and integral part of a society. The physical and economic development of the country depends on the labor class. Hence, the welfare of workers is paramount. In a country where importance is given to the welfare of workers, not only the economic condition of that country is strong, but the labor class there is also loyal to the employer. In the matter of state of Maharashtra versus Alka, the Hingde AIR 1998 SC 2342, it was held by Supreme Court before removing the labor class from the slums. Alternative arrangements for their residents are required. Some similar views have also been expressed in the case of Alga Peri versus Municipal Corporation AIR 1986 SC 180. Big factories of industrial cities are developed because the hard labor of workers of them. His welfare is the first duty of the state. What is labor welfare? Labor welfare is a dynamic concept. This means that method of the person or community which is necessary in the context of its entire environment. Welfare is a complete concept that is involves the human sense of physical, mental and emotional well-being. According to National Labour Commission, the concept of welfare is essentially a dynamic concept that takes different forms in the context of country, time and circumstances and moves slowly. It means that it means that labor welfare means physical, mental and emotional development of labor. Labor welfare is in fact fulfilling the basic needs of the laborers. It is generally the duty of all welfare states to give importance to labor welfare and make it a part of their policies. The concept of a welfare state has been nurtured by the directive principles of state policy contained in the Constitution. The concept of welfare state is conceptualized in the Part 4 of the Constitution. It was said under Article 38 of Constitution that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic and political shall inform all the institutions of the national life. Justice Krishna Iyer has also been of the opinion that the spirit of our constitution is embedded in its preamble and the dynamics of its objectives have been replaced in Article 38. It is a concept based on social justice. The National Labour Commission reported in the year 1969 that directive elements of the policy of the state generally promote the welfare of the common man. While applying them to the labor class, the work has been given due and justified humanitarian condition. In this way, labor welfare altogether means all-round development of the labor class, fulfillment of basic needs and physical, mental and emotional development, its nature and scope. Labor welfare, as we have seen above, is a dynamic concept. It is directly related to the overall development and welfare of laborers. This can be seen in many schemes made by employers and labor unions such as health, safety, education, general progress, etc. Labor welfare is concerned not only with providing facilities but also with the creation of a clean environment where workers can breathe freely and develop their consciousness power. Labor welfare schemes provide an important contribution to establish industrial peace and awaken the feeling among the laborers that they have to strengthen a skilled labor force financially. The only goal of welfare schemes in the industry is to improve and improve the working conditions of the workers. The truth is that labor welfare is indispensable for the establishment of industrial peace. In the Declaration of Philadelphia of 1944, labor welfare has been given special importance. The field of labor welfare is very wide. The activities of labor welfare can include all the activities which are necessary for the physical, mental, intellectual and emotional development of the workers. It also includes economic advancement of workers. The fulfillment of basic needs of workers is also a matter of labor welfare. Labor welfare, many labor welfare may include the accommodation, medical, education, nutritional, recreation equipment, social insurance, share fund, gratuity, pension, proper working condition, risk compensation, etc. Collective Bargaining has also been considered a part of labor welfare. Today, every laborer wants that all the scheme of the physical and mental development should be included in the labor welfare so that they can be able to fully implement their efficiency in the process of production. Article 43 of the Constitution states that the state shall endeavor to secure by suitable legislation or economic organization or in any other way to all workers, agricultural, industrial or otherwise, work a living wage, conditions of work, ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities, and in particular, the state shall endeavor to promote cottage industries on an individual or cooperative basis in rural areas. Article 41 of the Constitution states that the state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. In this way, the area of labor welfare is reflected by the above deliberation and constitutional provision. Dear friends, tomorrow we will discuss the constitutional provisions regarding labor welfare in India. The ideals of welfare state in India are embedded in the directive principle of state policy enshrined in the Constitution of India, justifying India as a welfare state. Now, let us go through public international law and human rights. Public international law and human rights. Let us define international law. Let us discuss the true nature of international law. Let us evaluate the definition of international law given by Stark. Does Stark laws give the total conception of international law? Let us discuss also the basis of international law. What is international law? How does it differ from private international law? Let us discuss the basis of international law. According to according to European scholars, modern international law is a product of the modern European system. According to Afim, the origin of international law is necessarily a result of Christian civilization and its development began in the medieval period. This statement does not seem appropriate because there are many principles of international law which existed in ancient times and there are some which were present in ancient India in their developed form. Oppenheim and other Western scholars are of the opinion that international law is a product of the modern European system, not fair. The falsity of the said opinion of Oppenheim and other Western scholars is clear from the study of Ramayana and Mahabharata. Dr. Nagendra Singh, a famous Indian scholar, wrote that the study of memories makes it clear that ancient India had an evolving system of laws and rules of world which was based on feeling of humanity and well-realization. The rules of world were also applicable to those conflicts which are of the nature of civil war, and this notion is seen in modern times in the 1946 Convention of Geneva in the areas of peace methods too. India has made significant contribution. Apart from this, some important topics of international law, such as right to shelter, dealing with foreign nationals, immunities of ambassadors, beginning of the law of ancient years. It was done in time, but it has to be accepted that modern international law is a product of the European system, and some European countries have the credit for developing the form which is accepted today. International law terms were first used in England in 1780 by Jeremy Bentham, a jurist. Subsequently, the term began to be used to enlighten the rules by which mutual relations of members of the international community are controlled. Definition given by Oppenheim, according to Oppenheim, the law of nations are the international law refers to the name of a group of orthodox and traditional rules which the civilized states regard as binding in their mutual practices. This definition was given by Oppenheim in 1905. The definition of international law given by Oppenheim has now become outdated and inappropriate. International law has brought about revolutionary changes as a result of the events in the last 50 years. Now each important, now each important element of the definition given by Oppenheim can be challenged. Therefore, it has become necessary to redefine international law, but as Professor Friedman has written that redefining international law will be a continuous process because it will be similar to the topic defined by the first generation and given to us. In fact, international law is such a set of rules and common principles that continuously develop, which controls the mutual relations of the members of the international community. New definition of international law given in the ninth edition of the book of Oppenheim. It is mentioned here that the editors of the ninth edition of the book of Oppenheim, Sir Robert Jennings and Sir Arthur Watts, have changed the above definition given by Oppenheim. According to the definition given in the ninth edition, international law is a set of rules that are legally binding in states' mutual relations with each other. These rules primarily govern the relations of the states, but only the state is not a subject of international law. International institutions and to some extent individuals can also be subject to the rights and duties imposed by international law. It has also been clarified in the ninth edition that states are primarily subject of international law, but Kabul is not the only subject. the extent to which other bodies other than the state are presumably empowered with rights, procedure and duties can be called a subject of international law. Having international personality, not only individuals but also some regional or political units can be subject to rights and duties under international law other than states. Thus, the notion of international law, expressed in the ninth edition of Oppenheim's book, has become very close to the notion expressed by Stark. It still lacks that the general principles are not mentioned. According to J.I. Bradley, the law of nations or the international law is a set of rules and principles in practice that bind the mutual relation of civilized nations. In the SS Lotus case, the International Court of Justice said that by international law we mean the principles which apply between independent nations. According to Philip C. Jessup, international law or the law of nations is the method that applies to the mutual relation of states and relations of individuals with states. According to Hall, international law is a set of rules of conduct which modern civilized states consider binding on their mutual relation in the same way that a prudent person believes the law of its country which he has to follow and which is binding on him, the state. He also believes that in case of violation, international law can be enforced by the above mentioned means. According to Hackworth, international law is a set of rules which govern the relations of states. It is a system of jurisprudence that has developed mainly according to the needs of the experiences and circumstances occurring from time to time. In Queen versus Canage case, Chief Justice Lord Colleagues on Justice Lord Colleges and Autocrat said that this is a group of international legal practice that civilized states have accepted to follow in their mutual relations. According to Kelson, international law or law between states is the name of a group of rules that govern their conduct in mutual relations of states. According to Fenwick, international law can be defined in broad terms as a set of general principles and specified rules that govern the mutual relations of the members of the international community. Fenwick's definition is most appropriate. Among the definitions described above, Fenwick has used the words members of the international community. In this, the dominant states, individuals, international institutions, non-state units, etc. all come. Apart from this, general principles also come under the definition. According to Stark, international law is a set of rules which mostly contains the principle and rules related to the conduct of states which they feel binding on themselves and generally consider them in their mutual relations and under which also the following come. 1a related to the functions of the international institutions, their mutual relation and their states and rules relating to the method of relation. Yet be the rules related to the individuals and non-states units which are related to the international community. This definition is different from traditional definition. According to traditional definition, only the sovereign is subject to international law, so it controls their relations. But as Stark wrote, the traditional definition has become inappropriate as a result of changes and development in the last 4 decades because it does not make sense of all the rules of international law that are now part of it. The above definition given by Stark is appropriate because it gives a sense of the changes and development that has taken place till now. But Stark has made it clear that in practice it would be appropriate to remember that international law primarily controls the traditional rights and duties of a state. Dear friends, tomorrow we will discuss international law, its vanishing point of jurisprudence, how far how far this statement is correct in modern perspective. International law is the vanishing point of jurisprudence. Tomorrow we will discuss it in deep. Now you are listening. Your presence is praiseworthy, admirable, and appreciable. Last but not least, mediation, conciliation, and arbitration. Let us start it from the beginning. Alternative. Alternative dispute resolution system is gaining popularity and statutory recognition. Comment. What do you mean by alternative dispute resolution system? Let us explain. Means alternative means to resolve disputes. What are the reasons for optional dispute settlement? Recognition of is increasing in the area of law and in the commercial segment. Some of the reasons for its introduction were that litigation used to be tiring, expensive cost was limited, and access to the courts was limited. Initially, this method of settlement of disputes was not acceptable to the lawyers of America because big companies used to do a lot of litigation and an individual litigant was very weak compared to their ability. She used to stand against the weaker party even though it was known that the litigation expenditure would not be recovered even after winning this case. Since 1980, since 1980, a similar wave of success has arisen which provided an opportunity to test other ways of settling disputes by reducing litigation. Industry grew and trade crossed the boundaries of the country and became of a world nature. New methods of disposal were low cost and quickly brought relief. Between 1960 and 1980, there was a tremendous development in science and technologization that it had a profound impact on commercial life and created a way of world competition in the business world. Due to this, a movement was started to protect the interest of consumers. In the method of law, there was no visible preparation for combating this storm-like event which was seen in the commercial world. Therefore, the method of dispute settlement emerged as a powerful weapon which proved expeditious to settle disputes not only for domestic disputes but also for settlement of foreign disputes. And independent dispute settlement is emerging as a branch of separate and independent legal discipline. It establishes a way of setting the disputes of those people and business who do not reach agreement by negotiating with opposing parties. An important feature of a customary dispute settlement uh, is that through it a person settles the dispute without using the traditional litigation process, even if its decision is not binding on the parties, they can still come to court. That is why this method was named an alternative method. It is also believed that even though this method has started to be used, it is very difficult to run independently without any arguments or arbitrations. Despite this, the compassionate method is becoming more powerful than litigation and arbitration. There are many Disputes that cannot be settled by litigation. For example, if any problem arises in the family business and the family members want to be settled by negotiating with each other and not by litigation, then it is compassionate disposal may be the only appropriate method. It has benefited from the development of the principle of independent settlement that only those things will be brought out which are directly related to the joint interest of the parties to the dispute. Therefore, it is also called a suitable dispute settlement method. It is also called a friendly settlement as it attempts to create a friendly atmosphere in them instead of confronting the parties. Alternative methods of settling disputes. Disputes are a traditional method of disposal by courts. A judicial system is established by the state to settle disputes arising between individuals. The court follows a definite legal process in settling cases, but due to the excessive technical, complex, and expensive procedure followed by the court, the decision in the cases could not take place for many years. Even after years, if the aggrieved party gets justice, it is like not getting justice. Delayed justice is therefore not justice. Mr. Bhagwati, the former Chief Justice of the Supreme Court, had said the truth about the Indian judicial system, that our judicial system is overcrowded with excessive burden of work and is on the verge of breakdown. With the current judicial system being delayed with also very expensive, poor and helpless people are deprived of getting justice. Therefore, as an alternative to the judicial system for settling disputes, certain methods have been given legal recognition through which individuals can get quicker and cheaper justice. These methods are placed under the customary dispute settlement method. As an alternative to the judicial system, a new section, Section 89, has been added by an amendment in the year 1999 to the Code of Civil Procedure 1908 for settlement of disputes. Some alternative methods of dispute settlement have been recognized in this section. The following provisions have been made in Section 89 of the Code of Civil Procedure 1908. When it appears to the court that there are elements of a favorable settlement of the dispute which may be acceptable to the parties, then the court shall decide the terms of the settlement and hand it over to the parties for their comment, and their receiving such comment, these terms shall be the subject may direct the settlement of the disputes in any of the following ways. One is arbitration, reconciliation, conversation, judicial settlement, beach rescue, neutral assessment, neutral assessment at the beginning of the dispute, evaluation of the total case, trial by brief jury, neutral conclusion, short trial, settlement week, as per the consent of the parties by the special magistrate. Section 89 further provides that when a dispute is directed to the arbitration or conciliation, the provisions of the Arbitration and Conciliation Act 1996 shall apply as if the dispute was directed under the same act for settlement. Dear brothers and sisters, tomorrow we will discuss what are the pacific and compulsive means of settlement of disputes. Thank you. I thank all my brothers and sisters. I thank all my teacher, trainers, professor, professionals, listener, learners, officials. I thank all my respected doctors and directors. I thank all my adorable ministers and managers. I thank all my honorable advocates, advertisers, administrators, and advisors. I thank the most honorable President Professor Modi. Thank Thanks a lot